This is the Giraffes Don't Eat Steak podcast, a show that brings you marketing stories, tips, hints, and much more. A treat for those who want to succeed in business or marketers who just want to learn.
Hello, good afternoon.
Good
Hi.
afternoon.
How are we doing? It's pouring here, absolutely pouring. So there was some sun, but no more.
It's good for your gem squash.
Yes.
If you planted your gem squash yet.
No, not yet.
Isn't it time to start planting things?
Soon. But they do need sun as well. So
Yeah, my worry is that it's time to start cutting the grass, and the rain is going to make it grow, and I've been putting it off, so not too happy about it. But it hasn't begun.
fantastic. Well, welcome to our listeners. Today we have a guest, and our guest is Alex Marks, who is a commercial and business lawyer. Welcome to Giraffes Don't Eat Steak, Alex.
Delighted to be here. Thank you for having me.
So we already have discussed the problems I'm going to have with two Alexes in the room. And so I'm going to be doing Alex M for our legal friend and Alex B for my marketing. There's not a good word to call you, Alex B, but yes, my marketing friend. So to say that, I almost got into trouble. Okay. So the reason we've invited Alex M to join us today is we did a podcast a couple of weeks ago about the difficulties or how difficult it is for marketers who see their clients copy pasting terms and conditions onto websites. So that's really where we started, Alex, is, we're marketing, but we're kind of advising our clients on the law when it comes to GDPR, marketing permission. They're like, here's a list, please just mail it for me. And we're like,
Yeah.
Where did you get this list? Do you have permission? Are we allowed to use it? So we kind of blur the dots in terms of guiding a client in terms of doing things the right way.
Often step into a very uncomfortable zone, right? As a marketer, because we kind of know the laws, I guess, we know that it's not okay. But we do not have the foundation and not because we're marketers. We don't have the full depth and the gravitas of someone who has been studying the law. And often we find in that awkward situation where we say that we need to do something, but sometimes, I don't want to go through a lawyer, blah, blah, blah. But ultimately there's a huge benefit to it.
Yeah. So the one scenario, and we'd love you to chime in here, Alex, I'm sure you've got lots of these examples as well. The one scenario is a customer has come with an Excel spreadsheet of names and email addresses and gone, Erica, let's do an email campaign to all these people. And it turns out they got this list from their previous workplace. What would be your opinion on that, Alex M?
Well, if we're just talking about the marketing aspects, I don't need to tell you what the regulations are, but you have to have consent to send a marketing email. And I just had, actually last week, an organization came to me that is marketed on a nationwide website, and the owner's going to close the website, and he's got thousands and thousands of people on the website, and they were thinking of buying it. And I said, well, you must absolutely make sure that all those people have given a consent, because once you start sending out emails to these people, marketing emails, some of them will complain, because that's just the nature of things. And we know that it's important. So that really leads me on to a lot of the issues that I personally find in the work that I do, which is always, you say, legal. So you're advising a business on marketing, because every business wants to sell,
Yes.
right? That's why That's why they're in
Absolutely.
business. They want to sell, whether it's goods or services, and actually they don't think about it. They don't care about anything else. I get the problems.
Yeah.
So when things go wrong and there are issues and people come to me, I discover they don't have terms and conditions, or they don't have a privacy notice, or they don't have a pre-policy, or they don't have anything. And that's where the fun starts.
So I think you shared with me a while back about a client you were helping who didn't have the right terms and conditions, and they got into trouble. Could you want to share with our audience that scenario? Because that was an interesting story.
Well, there are several, actually. So I think the one thing that I should say is that with a good set of terms and conditions, it really sets out your relationship with your customer or your client or even your supplier, and you can get into so much trouble otherwise. Now, I would like to tell you about a lovely case that involved an emoji, if I
Yes.
could. And the actual, I'm not going to bore you with it, but the actual case, just so I can prove it's real, is called Southwest Terminal versus Actor Land. And basically, Mr. Actor was a farmer of flax, and Southwest Terminal wanted to buy the flax, and they sent a contract saying, we're going to buy X amount of flax, and the price was quite low at the time. And they said, do you agree the contract? And the farmer sent back an emoji, a thumbs up emoji. That was it, nothing else, no signature. Anyway, the price of flax went up. So it was going to cost the buyer £800,000 more to buy the flax. And they decided, no, we can't do this. So they said, there's no contract. And it went to court because there were no terms and conditions setting out how you make a contract. And they lost because it was held that the thumbs up emoji was a sufficient acknowledgement. So that's a case where a set of terms and conditions that says this is how we form a contract would have helped the day. And that's just one example.
A thumbs up emoji. Wow. So hold on. As a marketer, that gets me excited. Can you thumbs up to say, yes, I give marketing consent? Is that considered marketing consent if you send back a thumbs up emoji?
So in this particular case, the emails that were trading backwards and forwards were very light-hearted, and there were lots of emojis, and so it would work. But I suspect it would work, actually. I suspect it would be an acknowledgement. So, yeah, I would be comfortable to rely on that if it happened.
It's an affirmative yes, like accept or agree, right?
It's also work, yeah. Yeah, it'll work, yeah.
What do you think, Alex B, for some of our more light-hearted clients? We don't have to put the formal tick box. You can just say, give us a thumbs up.
Have a like. I mean, effectively, it's the same, right? It's the same button. It's just a different icon or word. But it's a positive, what's the word? Positive indication that they agreed.
Very interesting. I need to be careful where I send emojis now, just in case people are taking it as contracts. So back to GDPR and this marketing list. The marketing permission was given at the previous client, but am I correct that marketing permission is specific to a business? So you give, just because you gave marketing permission at company X and the person moves to company Y, doesn't mean the client's marketing permission transfers. Am I right?
Well, you would have to have that permission to approach them and say that we want to continue your marketing with the new owner. So you would be correct in the same.
Okay.
But you know that there's a difference between what's called a hard consent, which is where somebody ticks a box and said, yes, I agree, and a soft consent, which is where they originally ticked the box and said, yes, I agree. And then every time you get in touch with them, you tell them they can unsubscribe them and so on if they want to. So yeah, you're quite right. You need consent, and that's how it goes today. Which when I look at my inbox is no bad thing actually, because it's full of stuff I didn't ask for that gets sent to me.
Yeah, I often go on like a monthly unsubscribe spree. And when it gets to a point where my inbox is starting to be full of emails that I'm not that interested in, and I'm not really sure how they ever arrived in my inbox, actually, I always do a monthly cleanse of unsubscribing.
Really? Are you that dedicated? Every month?
Yeah, because I don't know what it is, but I cannot stand emails where email accounts where it's just you've got loads of unread emails, or when I wake up and I've got 500 emails, but only 2 of them are of interest. That gets to the point where I'm like, no, unsubscribe, unsubscribe, unsubscribe. It takes a while, but it's worth it.
You should not look at my email box. I currently have, let's see, 143,030 unread emails.
That would make me vomit.
So let me tell you about my client, if I may.
Yes.
Public knowledge, because they got fined, and I have to say, not through any advice that they took from me. They did this all on their own. This is a company that sells double glazing windows, conservatories, home improvement, and they started doing unsolicited email marketing. They went out to a third party company who assured them that they were doing things the right way. And it turns out they weren't. And there were about 20 complaints sent to the Information Commissioner's office. And when you get a letter from the Information Commissioner's office saying there's been a complaint, it is not a letter, it is a pack that you have to answer. And inside that pack, it says that directors can be personally liable as well. And they got fined £100,000.
Wow.
And this is one director, 8 employees, and that's what they got fined for breaching the marketing rules. So it really is important. It does matter. And I know that a lot of people think it's not going to happen to me, I'm too small, but actually it depends on the complaint. So it's always worthwhile speaking to an expert like yourselves, really, on marketing and getting that one sorted out.
Oh, I try, I'm sure you do, Alex B, as well. I try and refer to legal experts. I can say to my client, I'm not sure that's the right thing to do. My understanding is we're not allowed to mail to that list. Yeah. I suggest you consult your own legal advisor, right? Because
I think it's very wise. Yeah.
You do the same?
Yeah, I think it's very wise because it's not our speciality. If you have a doubt, you need to check that doubt out, and speak to someone who knows for sure and has been through these cases over and over and over again. It's really worth it. If maybe the small price you pay just to get someone else in to have a look is absolutely nothing in comparison to, well, take this example, the £100,000 fine for a one-man business with 8 employees, as you said. It's absolutely worth it. Let's not risk that fine because that can crumble a business.
Absolutely. And for me, in my consultancy role, because I'm pressing send on the email, I'm also like, I don't want the company to then blame me, but Erica, you sent it out, right? So I want to make sure it's documented. I've said this is not good based on my experience. I've given you advice to go and do it. There's a fine line. What do you suggest, Alex? If a client insists that I must still do the send, right? They want to send it. I'm saying you don't have permission, you should do it. Do you think the best thing for me as a marketer would be to say, I'm not going to send it, get someone else? Or like, what's my position?
Right. Well, you're not a director,
no,
and you're just being told to send out a marketing email. Your position should be that you've given them advice and you've got a record. that you've given them advice and you've advised them not to do something without making sure they've got consent.
Yeah.
And if they go ahead anyway, it isn't going to land on your shoulders. It will land on the company's shoulders and the directors. So that's where you would be standing in that situation. But it's uncomfortable because you don't want to be something that you know is a breach of a regulation.
I don't know what I would do. What would you do, LXB? Would you still send it?
I'd like to think that I would never be working with someone who would put me in that position if I insisted that it really doesn't seem right, that they would say, just send it anyway. I honestly have never been in that position.
Yeah, me neither.
I really hope I never am. It seems like you need to probably question the relationship you have with the person if they still say send, if they're not listening to what you're saying. I would just reevaluate your position, maybe quit.
You know, you're not breaking the regulation, but you're being put in a difficult position where you're giving advice and your advice isn't being listened to. So what do you do?
Yeah. And GDPR is, you know, a lot of the work I'm doing at the moment is B2B. And a lot of the pushback I get is GDPR doesn't apply to B2B, right?
Well,
but you're like, there's still a person. There's still a person.
Correct. It is true that business to business, you don't have the same data protection regulations. That's absolutely true. But if you're sending an email to Fred Logs or Sally Logs at a company, that email address is personal data.
Yeah.
It applies. If you're sending it to office at or info at or accounts at, then no, it doesn't apply. And then you're clear of the GDPR. So it really does depend.
I think that's a really key point that we should bring across in the podcast, because that is a huge myth that I've also come across many times. Oh no, it's business to business, we don't need to do it. If there's a name in the email address, it applies. If it's an object or a noun, no, that's not right. Sorry, because it's a name. No. But if it's office or
verb or help, help at,
then you're okay.
Yeah, it definitely is a myth that's going out there, right? That but as soon as you it's a business, you don't have to care about it. And then here's an interesting one that I was asked the other day, and I won't tell you what I thought the answer was. Let's see what you say, Alex M. Does GDPR marketing permission expire? Or is it for life?
It's not for life. And it has to be, the consent has to be refreshed, because the whole point about, or one of the points of the GDPR is that people have got the rights to change their mind. They've got to cancel an instruction. And how do you know if they still consent? So the difficulty with using consent as your lawful ground is that it has to be a fresh consent. So you should be checking every year, really, to make sure that the consent is still there. You don't have to worry about that if you're doing, for example, legitimate interest or contracts. Then it isn't a concern, because those are the reasons that you can process personal data. But with consent, no, it's not right, because the whole point about the GDPR is the right to be forgotten, or, you know, the right to change your mind.
And if it was every year, would we be doing a hard consent, like, you know, we're refreshing this, do you agree to do it? Or is it the more of a soft consent that we were talking about earlier?
Well, I think it has to be a hard consent, because you're asking them to confirm something. And if they don't confirm it, look, I've said a year because it's a procedure or a protocol that you can think about. There is no time limit for it. It could be 5 years, it could be 6 months, or 2 days. People can change their mind at any time. So you really need to put something in place that shows that you're following a procedure and you're asking for consent. And if you don't get consent, then you have to assume that consent is withdrawn.
Okay, so that's something I don't think I've implemented that before. I need to think about that.
Me neither. And with a regular unsubscribe button on every contact, that's not sufficient in respect of the continued refreshment of the permission.
No, I wouldn't say that it wasn't sufficient. It could be sufficient. Unfortunately, every single case has to be looked at in their own merit. There isn't a sort of either or with all of this. If you don't ask for the consent to be refreshed, you could always fall back and say, well, they didn't withdraw the consent. I have the consent, so I continue to use it. It's just one of those things that every case is different. You don't know. So if you don't have to ask consent every time you want to send out something. So
Okay.
what is a reasonable period? And you're just looking at that to make sure that if you were ever investigated as to what are your data procedures, what do you put in place? You know, there's no, it's all about, am I doing something? Am I paying attention to the ethos of the GDPR? So
Yeah.
it's not ticking boxes so much as showing that you've got procedures in place and that you're following.
Yeah, that makes a lot of sense.
So I have a burning question.
Go.
We are obviously now in the world of AI, and a lot of tasks are done through AI. And for a company that is small and has little to no resource, I know a lot of the stuff that they're doing is via AI, ChatGPT. Can they ask for a privacy policy or a cookie policy via ChatGPT, and is it sufficient? And or what's your thoughts on the world of creating legal content via AI?
Absolutely not sufficient at the moment, because what you don't know is where they've gone to get what it's producing for you. And you don't know whether they've gone to a good source or a bad source. And I can tell you that I look at so many privacy policies online that are effectively. For example, when they say this will be determined by the laws of the Delaware or California, you know, but people cut and paste. So I would be very loath to rely on anything produced by AI that you wanted to be legally 100% secure. I really don't think you're going to be secure for quite a long time yet. And I'll go a bit further and say that there could even be a breach of copyright. So somebody may have the copyright in what's been produced for you. And as a result, and I'm not saying this is 100%, but I did read it, that Microsoft and Google were offering a limited indemnity to people, because if they relied upon their chatbots produced work, it's possible it was breaching somebody's copyright. So yeah, I don't think it's no doubt it will get there.
Sure.
Another interesting point with the AI is you can actually ask the AI to argue something from any angle.
You can.
So just as you can say, argue that I don't have to refresh consent, and it will, you can also say, argue I do have to refresh consent, and it will. So which one are you going to rely on? You know, so as I say, each case is different, but it's interesting.
That is very interesting. Yeah, and the copyright thing is even because, you know, people use it for copy, right? For writing blogs and that kind of stuff. But again, if it's just gone and taken it off someone's website, you don't know where it got it.
Yeah.
You could be in breach. We had, and it's similar, but Alex and I were looking for logo designs once. Do you remember, Alex? And we went to this site, I won't name it, and we found some designers, and they gave us really cheap prices, and then they gave us a whole lot. But I don't know, we just so happened to know that those was other people's logos that they had just copied. Like literally was a whole lot of copied logos. And they were selling it to business owners as unique. And we just thought, oh, how many people are being fooled by this, right? That are paying their $50 or whatever it is, thinking, oh, this is a good deal for a logo, but they're actually using someone else's logo.
Yeah, and the designer is not going to get into trouble, I guess. I'm not sure. Well,
I mean, with regard to AI and the use, another thing that I would mention, and this applies to design, by the way, and logos as much as copyright written work. The cases, there are always new cases coming along which interpret what the law says, what the statutes or regulations say, and they're changing all the time, from day to day sometimes, or month to month. So you actually don't know that what the AI produces is safe and secure, because a case may have looked at it and said, well, actually that isn't, and said you can't rely on it. So, you're always better off going to a lawyer, but I would say that would be fine.
Yes. I don't know. And I mean, to your earlier question, I don't. By that stage, the design is gone. I mean, when you buy these things on these sites, right? They're gone. You usually don't even know their name, right? You usually have just some username
yeah, but
on
it's
the
the same
thing.
case, I guess, as what Alex was describing in terms of sending in emails to a list that doesn't have permissions. If you, as the marketer, doesn't press the send button, you probably won't get into trouble. It'll be the owner of the business. It's the
Yeah.
same with the logo, right? If the
Yeah.
designer designs it for you, but it's still your choice to use it or not.
Yeah.
Can I just say that you would get into trouble if you did it without going to the owner and saying you can't do this.
Agreed.
You shouldn't do it. I mean, if you just did it, of course you'd get into trouble, because they would say they're relying on skill and expertise.
Yeah.
Why they employed you, or they're using your services. So, Erica's point was that I've gone to them and said you can't do this, and they're still telling you to do it. But I think if you did it without that process, then yeah, you would get into trouble.
No, and that's a really good point. And that's why it's important for marketers, even though we're not lawyers and we're not expected to be, to still be aware, very aware. And Alex, you and I are probably lucky because we spent most of our marketing life in insurance, which is so regulated that we were trained in the legals more than the marketing. And so it's kind of imprinted on our brains, right? To look for the stuff where other marketers, especially I see young people today that have just trained in graphic design or in copywriting, whatever, that haven't had that exposure, don't even know about, copyright, about GDPR, about permissions. They don't know, right?
That's very true.
So Alex, we've discussed GDPR, which is a whole minefield on its own. I think we could probably do a whole episode on that, but let's not. We've touched on terms and conditions, website terms and conditions. Again, don't copy it. Speak to a proper lawyer. Make sure it's appropriate to your business. Any other tips that you think just on website terms and conditions?
Well, I mean, I think they're so essential, and I've come across people who don't have them at all.
Yeah.
And who just have emails to set up the business. And again, when something goes wrong, the obvious examples are, oh, that person went behind my back and went to the client direct, and I can't stop them because they've got a term in the contract, and they can say, oh, well, no, it was implied, but the courts won't imply terms. They won't rewrite a contract. They'll only try to make sense as to what people meant. And then there's something called the contra proferentum rule that says that if something is vague and it could have two meanings, the person who wants to say, well, that actually meaning supports me, they lose. So they should have had, a very clear term or condition saying this is what the situation is, and not try to rely on an understanding. So I would say to anyone, frankly, if you're in business and you want to avoid problems, you've got to have contracts in place, and they have to be right for the services you're providing or the goods you're selling. They've got to deal with things like refunds, cancellation, delivery, passing of risk, indemnity, you name it. And if you haven't got that, you're just waiting for something bad to happen. And I say it's like driving without car insurance. it's great until you have an accident,
Yeah.
and then it's not so great. So, that's my view. However, businesses always look at sales, and it never surprises me. Fails to surprise me that they'll spend a fortune on a fancy website, but they won't spend a small amount on a contract. And I can't put the two together, and I just feel that they haven't really budgeted or put a proper business plan together if that happens.
Nah, I think you're right. And supplier contracts are just as important as client contracts. Last week, my client had been using the supplier for ages, and I needed branded T-shirts. So they said, here's the email address of whatever, just contact them. So I contacted them going, hey, you've done this before for this client. I'm looking for this. So we did it all on email. Naughty me. Okay. So I'm saying this up front, and paid the invoice. No, I didn't do a contract. I assumed incorrectly that there was a previous, if they'd done business before, there was some sort of contract. But anyway, naughty me. Made sure, can you make sure they get you by X date? Yes, of course. Yes, of course. Date arrived, I've got no T-shirts. So I emailed saying, hey, no T-shirts. You said they were going to be here. They're like, oh, we don't deliver. You have to come fetch it from our store. I'm like, but you're in Manchester, and I'm in Oxford. How did you think this was going to happen? And they're like, no, that's always been how we've done business. And I was like, and I couldn't be mad. I could only be mad at me, right? Number one, I didn't ask for either a copy of the existing contract so I could see these things, or, which there actually isn't a contract, put one in place. And then I would have spotted this. Oh, you don't actually deliver. I have to drive all the way to Manchester to go and fetch it. So then I wouldn't have used them, right? I would have gone and found a new supplier. So yes, I suffered. I now have a box of when I went up to Manchester, I went to go fetch them. So now I have a box of T-shirts, which I've missed the deadline, so I don't have use for now. And we had to go to event without them, so it wasn't what we wanted. And yeah, shame on me, right? Just so supplier contracts, as you say, the email is not good enough because there's detail that you need to check out, like, do they deliver?
Yes. Well, I mean, what a shame you didn't bring that to me sooner, because it looked like something you could have cancelled.
Oh,
But anyway, next one.
ah, now you tell me. I've still got the box. Can I take it back?
Are they good T-shirts though?
Sorry?
Are they good T-shirts? Are they good T-shirts?
No,
Oh.
we're not.
I think that is another thing, though. There are a lot of assumptions that we make going into a business, especially if the business looks beautiful and well manicured. Going into a new role into a business, it's not a bad thing to take a little audit of some of the items that you're working with and just understand, what are the terms of some of the business that you're doing. And especially as marketers, we have a lot of suppliers quite often. And you don't want to be put in a position like yourself. I mean, it could be worse. It could have been something that was extremely high value, or I don't know, like a TV production, for example, and you may just be working with that company because they've always worked with them, but you've never been through the contract process with them, so there may be something that is amiss.
Yeah. And it could have been more vital than T-shirts, right? And it could have really messed up my day, or my client's day. So luckily it was T-shirts, but still, naughty me.
The point still stands though. It doesn't matter if it's T-shirts, TV production, or something else, right?
Get your contracts in place and check.
So I've come across this in two different scenarios. One was with somebody who was moving house and hadn't signed terms and conditions, which said that if you lose something of a value greater than £40, unless you send it to us and tell us what it is, we will only pay you £40. And she hadn't read that and signed, therefore she actually lost as a result because she hadn't read the contract.
Is this with
And
Is this with the movers?
Movers, yes.
Ah.
And another interesting one where there were terms and conditions that were emailed. They weren't on a website, but because the company, and this was a very big oil production matter, because the company never signed an acceptance of the terms and conditions, they weren't binding because they weren't on the website, and that they were just in a contract, and there's a case on it. And as a result, they had to pay out, the company that was in fault had to pay out millions because the indemnity that was in the terms and conditions didn't apply. And the court simply said, yeah, there is a contract, but it doesn't include those terms and conditions. They weren't on your website, therefore, no notice of them was given the other party. So it's all fascinating. It's really, every case is different, and they're always interesting.
Right. Well, thank you, Alex. Alex B, anything else we want to ask Alex M?
No, I think we're good. I would just, maybe we can just give a key highlight. For me, it's the B2B. If it has a person's name on it, the permission still exists, and you need to obtain that permission. It's still the same as B2C in that world. If it contains office, HR, or whatever, it's a different case.
Yeah, okay. For me, yeah, I need to rethink this marketing consent refresh. That was new for me. I need to think about how long do we wait? What are the different principles, and just where do I put that in the process? So that's my big takeaway. Alex M, if you want to leave our listeners with your top tip, what is the one thing you want to leave them with today?
Come to you guys for marketing. Your expertise is very clear.
Oh. Thank you. And in terms of contracts or legal, what's the one thing you want them to remember after listening to our podcast today?
It's so easy to get someone like me to review them.
Yeah.
And just get them reviewed and make sure that it's better to head the trouble off at the pass. Don't have trouble, because afterwards it's often too late and it's always more expensive. So just get a review. It's easy.
And if any of our listeners want to contact you, Alex, what's the best way to get hold of you?
Well, my email address, alex@alexanderpls.com. I'm on LinkedIn, where I can be found. And my phone number, 07999 065 768. I'm always happy to speak.
Fantastic. Thank you so much. So if you've heard anything and you want to ask Alex, it's Alex Marks.
Not Alex B. Do not ask Alex B for legal advice.
Please do not ask Alex B for legal advice. Or you could just ask Alex B and myself, and we'll refer you quite happily, not give you advice. Thank you for joining us today, Alex. It's been an absolute pleasure. And yeah, we both learned something as well, which is always fantastic. Have a great day.
That wraps up this episode of Giraffes Don't Eat Steak. Thanks for joining us. I hope you found value in our discussion and got some new ideas to apply to your own business. Tune in next week for another round of marketing insights and inspiration. If you enjoyed this episode, please leave us a review and subscribe on Apple Podcasts, Spotify, or wherever you listen to podcasts. We appreciate you listening. Catch you next time on Giraffes Don't Eat Steak.